Okay,
Yeah. Okay, I got the recording on, so happy Tuesday, everybody. I see Joey and Felicia are online. Is that correct? I didn't see everybody else here. Yep, just Joey and Felicia. Today we're going to talk about the escrow process. What we do, a lot of times, we receive the contracts and the agents only are aware of what we need when we request something from them. They're not really aware of the actual process of everything that we do. So we're going to kind of explain a little bit of everything that we do, how we read the title report, and what kind of things that we need, the items that we have to satisfy for us to be able to record and insure the new lender and make sure everything's clean on title when ownership is conveyed. The first thing we're going to go is, where's she at here? Is here. What is an escrow? Escrow is a deposit of money and documents by two or more parties, which would be a listing agent and the selling agent, with a third neutral party, which would be us, the title company, where we hold the third party until certain conditions are met. We will hold earnest money. We'll do a search of the public record for title insurance and so on. Once you drop off the contract and the earnest money to us, we will start the process, which will be opening escrow, looking for a title report, which will search public record. Looking for any items that might be on title of that property. We'll also initiate a homeowner association demand if there is one, and then pay out information once we get that from the seller. Let's see here. It talks about the other parties in addition to the real estate agent, title company, escrow officer, lenders, mortgage companies. A lot of times when we receive the contract, we usually don't have the party's information, the contact information. We normally just have the signatures on the signature page of the contract. So if you can remember when you send in the contract to include your party's information on the email, mainly a phone number. If we have a phone number, we can call them, we can get the rest of the information. We can get their email address, we can get their mailing address and so forth. It's very important if there's a homeowners association, the homeowners association almost always require the buyer's mailing address and an email address so that they can get the CC&R documentation for them and any other things that they need to make the buyer aware of before they purchase the property. So it's very, very important that we get that information as soon as we can. The other things that we do here is we'll do the well site, that's, you're talking about rural stuff, meets and bounds, that kind of stuff. This one here talks about a variety of people that might be involved. Home warranty, that normally the selling agent will get for us. Exchange company, if there's a 1031, we're starting to see those occasionally as well. Attorneys we don't see very often. Payoff lenders, we almost always have payoff lenders. Inspection companies we don't normally deal with like we used to back in the day. And solar companies, since there's solar out there more prevalent, that's starting to become an issue. The other thing is with solar, it is very, very important that the seller initiate to the solar company that he is selling the property. Once that is, once the solar company is informed by the seller that they are selling the property, at that point, then the buyer can contact the solar company, and then they have to set up a profile with the solar company, and the solar company has to prove them through basically a credit search to prove them to take over the solar. That can take some time depending on the solar company. Tesla's pretty good. SunPower's pretty good. Mosaics can be a real pain in the butt. There's some that are just difficult, but for the majority of them, they're starting to get better at it and be more expedited about the process itself. We have had on occasion where we've had a transaction get delayed by about 3 days because we were waiting on the solar company to finish processing their paperwork. Also involved with the solar, there's a UCC agreement that has been recorded with the current seller that has to be released, terminated, and then once the property is sold, the solar company will go and put a new UCC in favor of the new buyer. And that can take that usually doesn't take time, but the solar company has to process their paperwork to be able to get us a UCC termination for us. And we do need that to record and proceed with the transaction. What else we have? Let me look real quick at my notes here. We'll also need lender information because the lender will reach out to us for their title request. They're gonna want a copy of the title report. They're gonna want a copy of the earnest money deposit with proof of how we received it, whether it's a wire or with a by check. They want proof of the check. They need to verify the funds. They're gonna want the title report. They're gonna want a plat map. They're gonna want a closing protection letter. So there's a couple of things that the lender's gonna want as well. So we need that information as soon as we can too, so we can update our records and have their information in there. And when they do the title search, we know who the lender's gonna be. That's important as well. So once we do get the contract, the other thing we will do is we will search the county assessor's office, whichever county it's in, and we will verify that the seller on the contract is the actual person who's entitled according to the state or the county that they're in. On occasion, it happens where the person who is on the contract is actually a representative for somebody because they've been deceased. That happens. The more you know about the sellers and the parties that you can provide to us at the beginning, the easier it's going to be for us to process, and the sooner we can take care of things as the transaction goes along. Any questions yet for anybody?
I do.
Okay.
On the HOA, do they typically email it or is it always US mail?
It's usually email now
Okay,
because the files are so big. You have some that have maybe 1 or 2 CCRs, and I've seen some that have 6 or 7 CCR.
yeah, 'cause if they mail them, that can close it away.
Right.
And for the solar, what's the process if the solar is owned?
If the solar is owned, usually it's just a matter of contacting the solar company, letting them know that the property is going to be sold. And they usually, all they want is that after close of escrow, we provide them a copy of the recorded deed. And then the new owner can contact them. And then it's just at that point, it's a matter of transferring the warranty and anything over that has the solar since it's already owned. Yeah.
And I just an input on the trust thing. I've had several and I had to provide there's a certain page of the trust that you have to have.
It's either called trust certification or certification of trust.
Right, and then they need all the trustee information.
All that information is usually on that one form.
Okay.
Yeah, because back in the day, they didn't include that. And we would request a copy of the trust, and a lot of people didn't want to disclose that because it basically shows all their assets. It
Yeah.
shows everything that they own. So we would request the first page, who the successor trustees were, who the beneficiaries were, and a signature page showing the notary's stamp. Now they've gotten better and they've actually put that into one form, just that stuff, and it's trust certification and certification of trust. It's usually on the first page of the trust for that reason. Okay, any other questions, anybody out there? No? Okay, so we'll go to the next page. What is escrow deposit money? We just did that, didn't we? This is regarding a refinance. This doesn't really pertain to you guys because you guys are doing buyers and sellers and resale transactions. Escrow responsibility as an escrow company is to act as a neutral third party. We're supposed to work, even though you are a client, we have to be neutral, and we have to be neutral to both parties. Once we're informed of something from one party that affects the transaction, we have to let the other party know as well. Okay. We'll hold documents, monies required for purchase, and guaranteeing no funds or property will change hands until all of the terms and conditions of the contract have been met. On that note, this is an issue that I come across a lot, and it's really nobody's fault. It's just the way it is. My name is Arthur A. Cedabaca Jr. I go by Art Cedabaca. I write a contract. Yep, Art Cedabaca, and Mickey Cedabaca, my wife. Well, when I go get approved for loan, they're going to look me up as Arthur A. Cedabaca Jr. When they create the documents, the deed of trust, they're going to have as Arthur A. Cedabaca Jr. The problem I have as an escrow agent is I have been given a contract for Art Cedabaca. So I can't convey title to Arthur A. Cedabaca because my contract doesn't say Arthur A. Cedabaca, it says Art Cedabaca. So then we have to do an addendum correcting the contract to read that the buyer is Arthur A. Cedabaca Jr. If we don't do that and I go in and I change the name from Art Cedabaca to Arthur A. Cedabaca Jr. on the conveying deed, and there was actually another Art Cedabaca that was actually, he could come back and file a claim. And that's why we have to be we have to be stringent and strict about that, that we have to have, make sure that the people on the contract are the same name as the people that are on the loan document.
And so what would you ask for to confirm how they're going, what their legal name is? Would you use their driver's license?
Normally what we want is how the lender's gonna have that. Because the lender, because usually what happens is the lender, and this is what happens 99% of the time, is the lender sends us loan documents for Arthur A.C. DeBaca, and we're like, whoa, wait, hold on, wait. I got a contract for Archie DeBaca. They're like, well, we've qualified him as Arthur A.C. DeBaca. He needs to be shown on title as Arthur, because the deed had to match the deed of trust, okay,
Right.
the securing document.
So it's important to use the name that their loan company is going to use and be consistent throughout all the paperwork. So if you've already written a purchase contract and you haven't used the exact same name that they're using for the lender, then you need to do an addendum right away to correct that name and then proceed to use it.
Correct, that's correct, okay? Was everybody able to hear that? About doing addendum and correct the name? I tell my people here, where my people go. I got 4 people now. Okay, so that's something that, and it's not a big issue, but just something we have to take care of before we close escrow to make sure that our contract matches what the securing document and the warranty deed is going to say when it conveys title. Back here, employed by and so to act on written instructions. Okay, so when we go by written instructions, a phone call is great for advising me what's going to happen. An email is great for advising me what's going to happen, but I'm going to need an addendum. I'm going to need an addendum to change something on the contract. I just can't do it because now if we work together, I'll go ahead and make the change trusting that you're going to get it. You know, if the first time we work together, I might say, okay, let me see, you know, okay, I got it. I understand, you know, once I receive the addendum from you, I'll go ahead and make the changes. This happens a lot when an agent wants to give a credit to a buyer. I see a lot where a selling agent wants to give a credit to the buyer for a home warranty. And if it's an agent I worked with quite a few times, I'll go ahead and make the changes on it, knowing that that addendum is going to come, or they're going to give me a revised commission instruction showing that credit from the agent. Okay, so I'm not a stickler for being, you have to give it to me, but if I work with you and we have a working relationship, I know you'll give me what I need. So that's not a problem there. Okay. Next is what I'm going screen here. Escrow officer role. Okay, this is our job. We're a neutral third party. We coordinate, assemble, and puzzle, prepare all legal documents required for the transfer of ownership. We coordinate with the title officer with requirements shown on the commitments, fiduciary roles, prep settlement statement, disbursement of funds, orders HOA demands, payoffs, coordinates a lender, signing loan documents, and record required documents. Going through here, the legal documents are basically that what we repair is going to be, mainly these going to go and be the warranty deed. That's going to actually convey the ownership. We have to do the 1099 forms for the seller, the non-foreign for the seller. The non-foreign, this is something that's not talked about a lot because it's kind of frustrating. It's frustrating for us. It's frustrating for the buyers. It's frustrating for the sellers. It's frustrating for the agents. It's frustrating for everybody. I just had one last month with a party. The sellers were Canadian. The buyer was a single woman buying a home. There are different requirements regarding a non-foreign and whether you have to do a FIRPTA, and which is Foreign Investment Real Property Tax Act. And that's to make sure that Big Brother gets his share of anybody who's not a U.S. citizen and profits from the sale of a transaction of a property. And going back to the party I had, the gentleman, the husband and wife were Canadian. They had sold property previously. They had an ITIN number. And when I confronted the gentleman, or since they confronted him, I asked the gentleman, are you subject to FIRPTA? He says, no, the US and Canada have a law regarding tax, so I'm not responsible for FIRPTA. I'm like, that has nothing to do with it. So he proceeds to tell me, he goes, well, yeah, I had an ITN number at one time, but that thing expired. I'm like, okay, so then you know you're subject to FIRPTA. He goes, yeah, I do. I said, okay. So we finally got that over that hump. And he's like, well, what do I need to do? I said, you probably need to call the IRS, contact them. And I said, I'm assuming it's like a tax ID number. Once you get one, it's never going to change for your name or who you are. So he ended up contacting the IRS and they, said that's my number. So he proceeded to give me his number because he wouldn't give me his information at first because he said he wasn't subject to it. I mean, nobody wants to pay more than they have to. I ended up having to hold, I think it was like $55,000 or $65,000 on the 15% of the sale of the home. And so, I mean, nobody wants to lose that kind of money, but unfortunately, he knew it was coming and he just accepted it. And I'll say he gave me his information. I went around with the selling agent because the buyer is actually responsible for filling out the paperwork for the FERPTA, which to me doesn't make sense, but they're the ones who are on the hook. If the person who's subject to FERPTA doesn't withhold the money, the buyer becomes responsible for whatever that amount could be. So me and the selling agent, we had a conversation and I tried to help him best I can. And like I told him, I said, unfortunately, we're not tax people. We're not tax professionals. We can't advise you on tax. We can tell you, we can point you in the right direction. We can tell you the website. We can even tell you what forms you need, but you have to complete them. The buyers have to complete them. It's the buyer's responsibility to complete them. It's our responsibility to hold the money. I spoke to the seller. The seller, he was finally in. He gave in. He said, "Okay, what do you need from me?" I said, "Well, the buyer needs your information. Is it okay if I disclose to them your name, your social security number, and your address?" And they said yes, which made it easy because the seller was in. I was able to get information to the buyer. The buyer was able to communicate, complete the information, and send the documents back to me. The seller doesn't have to sign any of those documents, the buyer does. And so when the buyer came to sign, I was able to have the buyer sign all those documents. Once we close, and I have to take all those documents, I have to make a copy of them. I have to provide a copy to the seller, provide a copy to the buyer, and I need to send the originals along with the check to the IRS. And then it's up to the seller to reach out to the IRS to see if he's entitled to any refund of any of that money. Okay. Again, that falls in the tax bracket stuff. I'm not a tax person. I don't want to be a tax person. Just trying to deal with FERPTA is enough for me. And I don't know if any of you ever had to deal with FERPTA? Yeah, they're not a lot of fun, but it's like anything else. I think once you do enough times, it becomes repetitive. That becomes a little bit easier and more common. I think that's probably more the issue than anything because it's just I haven't done enough. People that live in the West Side Sun City, my understanding, there's a lot of Canadian investors over there, and I'm sure they're everywhere in town too. But I do know they're pretty prevalent.
And it's the seller where that's important.
It's a seller.
If it's a Canadian seller.
It's a seller. Okay.
Is there anything in particular that has to be addressed when the buyer is foreign?
The government doesn't care when they buy them in their foreign. Okay, they don't pay any taxes just when they're going to make money. Okay, that's the way it is. That's what falls into when we do title searches. And this is what we have in here. We do title searches, and when we do a title search, we'll show any outstanding mortgages, liens that are out there, HOA information, well information, and then occasionally get a request for a statement of identity from Will Smith. I mean, Will Smith's a common name, so there's probably hundreds of thousands of judgments out there under the name of Will Smith, and we need to verify whether our Will Smith is the same as any of those other Will Smiths. So we'll require a statement of identity to be completed. It'll ask for first name, middle name, last name, driver's license, date of birth, citizenship, marriages, previous marriages, residences, previous residences in the last 10 years, occupation in the last 10 years, and previous marriages. Usually with all that information, we can determine whether there is a judgment out there for our Will Smith or not our Will Smith. On occasion, it is our party. And on occasion, our party tries to act like it's not them. They think if they just ignore it and then deny it, then it'll go away. And that's not the case because we'll normally verify by either social security number or date of birth or an address on the judgment that it's them. And then they have to deal with it. And what we try to do is if we find out it's them, we'll contact them first and let them know, hey, we see this judgment. It's under your name. We verified by your social address, whatever. Do you want to call them up and talk to them first before we request a payout statement? And I do that to try to give a courtesy to let them try to negotiate. Maybe they can negotiate a lower payment than what the judgment is, depending on how long the judgment and how old it is. But the creditor might just say, you know, just give me X amount of dollars and we'll just call it good. And, you know, you won't have to worry about it no more. You won't have to worry about it more. And it is what it is. So they'll normally call and negotiate if they can. If not, they'll just tell me to go ahead and order it. And then I'll order it usually from a law firm. And we'll get that payoff and we'll add that to the settlement statement. Any questions? No, not yet? Okay. Okay, so next page, let's go here. Common general rule at all times, if receiving inquiries on transactions, remember to be courteous but confidential. Discuss only information relevant to the particular party. This happens at times. The seller will sometimes ask for the buyer's information and we can't do that. I advise them at that point, you need to call it, you need to talk to your agent. Your agent needs to talk to the selling agent and see if you can get what you need from them. Why they ask that, I know we don't really ask that question. I just tell them that I can't disclose that information.
I think if correct me if I'm wrong, typically the only time that comes up is like when you're doing a contingent sale and so the seller of the house that we're in contract on wants proof from the buyer that their house is truly, under contract, or, and once it goes under contract, they want to see proof of that contract. I'm not sure how much you have to show them, but I overheard a conversation yesterday where the seller actually wanted to see the whole contract for the purchase of the contingent.
And that's something that would not fall under escrow's responsibility. That would fall under the agent's responsibility. That'd be the buyer's agent having to get that information and disclose it to the selling agent.
Yeah.
Okay, yeah. We don't get involved in that. We do a lot of transactions where people are buying or selling their property to buy another house.
Right.
And we get asked a lot for like the final settlement statement from the sale and that kind of stuff. And we just don't have privy to that information because we're not a party to that transaction. So as a neutral party, their title company can't disclose it to us because we're not involved in their transaction. If the buyer requests their escrow officer to send us the settlement statement, then that's a different story then, because he's given them authorization to contact and communicate with us. So, and that happens at times too. And a lot of times we'll work with the title company because they want to have their funds wired directly to us for their purchase, from their sale to their purchase that we're handling. So and vice versa, we do with sellers sometimes to purchase them, like they might be buying the other way around. So that happens a lot. And that's pretty common. So we just can't disclose information that's to a party who's not involved in the transaction. Okay. Let's see where we're at here now. Let me look over my notes real quick here. So. Okay, reasons for escrow. That's the next one. This is a good one here. Reasons for escrow. There is no state law requiring all property transfers to go through escrow, although escrow agents perform a very important role in a transaction. Has anybody handled a transaction that didn't have escrow? On occasion, we as escrow agents get a transaction that the seller obtained it through a handshake deal and a transfer of title. Okay. Now, we as an escrow agent, we're curious because we don't know what happened that time frame when it wasn't insured. If we know it was insured by a previous title company, we really don't have much problem because we know they insured it from the time that they did the transaction prior. So we may need to just fill the gap from when that buyer took ownership or that seller took ownership to him getting ready to sell to the new buyer. We handle the fund. That's important. So nobody has have to worry about handling any money. All conditions are met. And if you haven't looked at a title report, next time you look at one, if you go the second page in from not from the very first page, the very first page, the very first 4 pages just have basic information about the policy and that kind of stuff. If you go to the 5th page, it normally will disclose who the lender is going to be, who the new buyer is going to be, who the current owner is going to be. And then if you go to the next page, At the very top, it'll say Schedule A requirements. Those requirements are the things that we have to satisfy every one of those requirements before we can actually convey title and be confident that we can insure it without any, with minimal risk, I should say, because there's never any risk, but it's a minimal risk. At that point, we can convey it. All those conditions have to be met. It's gonna be payoff, taxes, property taxes always first, government's always first, okay? Government's always first, so it's gonna be property taxes and then any outstanding mortgages. And that's gonna be any HOA liens, and that's gonna be any other liens or judgments that might be against one of the parties in the property. A lot of times what happens is a husband and wife will be in title. One of the spouses will get a judgment against them. So they'll do a deed conveying the one spouse with a judgment and taking them off title, thinking that they're gonna sneak around the judgment. Well, when we go search title, we're gonna go look and see who the previous owners were on the title. And the fact that she removed herself from ownership does not remove her from the fact of the responsibility to pay the debt that was put on title when she was in ownership. So we would have to have her fill out a statement of identity so we can verify that was her. And then we have to pay that judgment through close of escrow. The other things that we have to meet usually is, those are the basic ones, requiring the previous mortgage to be paid off, taxes are current, and HOAs, assessments and everything are current, and when we convey title to the new owner. We also, now let me get into this while we're talking about vacant land, because everybody knows that vacant land, the forgery is up on vacant land. So what we have done is we have created some more documentations to actually reach out to the seller of the property to confirm that they are actually selling the property, because we've had some where people go out and find a vacant land, they know the property owner lives out of state, so they'll write up a contract acting like they are the property owner and try to sell the property and run away. It's happened on occasion, not with our company, but I've heard stories that it has happened before. It's happened before where they've done a contract, but we've been able to verify that it wasn't the seller before the actual transaction was completed. So we were able to catch it before it was done, but they're out there and they're prevalent. So we created a document that we got to send to the seller to verify, confirm that they are actually the seller and that they are actually selling the property. Let's see what we got here next. It's going to be a surprise to me too. I haven't seen it. Real property versus personal property. Anything the law considers immovable and is transferred by deed. Okay. Land, including airspace, condo, and within the ground, water, oil, minerals, anything permanently attached or fixed to the land, including the buildings, driveways, fences, and shrubs, easements, and water stock. I basically say if it's bolted down, you can't pick it up with your hands and move it, it's real property. Anything that you can move is not attached, washing machine, dryer, refrigerator, that to me is personal property. Blinds, curtain rods, those are real property. They're screwed to if you have to pull out a tool to remove it, it's real property.
You know where the question always rises, and I had a really bad situation on this one, is the actual draperies that are hanging from those rods.
Yeah, and that could be a sticky point.
Yeah.
The drapery. I mean, because there's just some things that are vague, you know. I mean, unless you write every exact thing down, there's always gonna be something in the gray area that, you know, that one time the person's gonna want, and it's gonna be big to do about it, you know.
Well, when you read that, you know, drapes are removable.
Right.
They're not screwed in, the drapes themselves.
Right. And the actual rods are removable, just the brackets aren't removable.
Right.
So can you take the rods and just leave the brackets, or you gotta leave the rods too? You know, I mean.
I had a couple that had to leave their baby, brand new baby, had to leave the nursery.
Really?
And then come find out the buyer was
Taking them down anyway.
took them down anyway.
It's just a mean buyer right there. Right.
But the buyer was asking them. Yeah, the buyer wanted them. And they were nursery. They were, you know, and they ended up scraping it was condo and made it an Airbnb. So Didn't even need those babies,
Right.
you know,
Maybe they just want it for temporarily.
Just to make it mad, I don't know.
yeah.
Sounds to me they just want me.
Like those curtains, they were in the photos and they're on the blog, so.
Also sliding door for the dog
That's it's attached.
was there, but they changed it.
They're not always attached though, the ones that go in the sliding door,
Right, no,
Those-
Arcadia door.
come right out, that'll
And
still
that's why
screw
they
in.
come out and
Yeah,
they wanted to wait, yes.
Really, yeah.
But
It's
they don't
amazing.
really need it. They buy
But
it
it-
like it.
To me, it's amazing sometimes that some of the things that's all,
yeah, it's,
Nitpick
it's
about-
almost ridiculous.
it's
sometimes.
like, you know, here, take the $50 and I'll go buy a new, I'll go buy a new door, doggy door in my next place, you
I
know?
had a 1.4 that wanted to take their TV
Really?
thing off
The,
the wall.
the bracket,
Are
the
you
TV
kidding me?
mount,
I'll buy you one.
right,
I mean, you're
right,
talking
right.
$200.
I'll buy you a brand new one and be
Yeah.
my party gift for you, huh?
It was like after 2005, like, I don't know when, but somewhere around the 7 or around there.
Right.
It was like, people were fighting, like, we had to leave the TV because it's attached.
Yeah,
Yeah,
well, and the TV itself, you do not have to lose because it's not screwed in.
But at the beginning,
Right.
I didn't,
Yeah,
didn't know.
but just the mount, you know, you'd be surprised at how many people, I'm gonna take my mount with me. I'm like,
yeah, yeah. It's amazing what people nitpick about. Yeah. Okay, now personal property, as I said before, anything the law considers movable and is not transferred by a deed. That should say movable, not immovable. And anything not permanently attached or affixed to the land, okay? So if you have let's say you have a shed that's set outside, those little plastic ones you get from Costco,
mhm,
theoretically, you probably take that, 'cause it's not really affixed to land, it's just setting on the dirt,
right,
you know? It falls into another one of those categories
yeah.
where,
However,
Yeah.
if they built some sort of a foundation
Foundation
to
for
it
it,
and
then
have screwed it in the
right,
foundation,
and it's
then-
fixed, right, yeah, right, yeah.
yeah, look at all the fun things.
Right, yeah. All the little nitpicky things that people
Yeah.
get excited about. Okay, title versus escrow. Now, I'm an escrow officer, okay? I have some background in title, but I've always worked in escrow. I worked in title, I should take that back. I worked in escrow. I started in 1995. Back in the day, in my opinion, they trained escrow officers differently than they do nowadays. We actually were taught title principles. We were taught about meets and bounds. We were taught about easeways. We were taught about plat maps, that kind of thing. Nowadays, they don't do that. Why? I don't know. When I train a person, I'm going to train them everything I know so that they have as much knowledge as they can obtain from me anyway. Title officer role is to research real property to trace the chain of title and ensure a clear title. Title actually goes back to the very first patent when the government split that land and conveyed it from themselves to whoever the land grabber was, or whoever the developer was, or whoever the buyer was, whoever wanted to buy that plot of property. It all goes back that far. We normally will only search from the previous transaction forward, because the previous transaction was searched by Old Republic, First American Title, Chicago Title, Fidelity Title, one of those title companies. And we know that they insured from when they covered it all the way back. So we normally just fill that gap in from the time that did it until we get the transaction. On occasion, you get issues like you might have a deed of trust that the previous buyer, I'm sorry, the previous seller had on the property when he sold it to our current seller, but it was never released. It happens on occasion. We will go back to the title company that insured it when our seller, when he was a buyer, when he bought it, and they paid off that seller's mortgage. We'll go back to that title company and we'll say, hey, can you give us a subordination agreement? And they'll go back, they'll look at the records, they'll say, yep, here it is on settlement statement. We paid X amount of dollars to Wells Fargo. We closed out the file. They never filed a release. So yeah, we insured it. And they give us a subordination agreement, an indemnity agreement. We use an indemnity agreement and we trust that they're going to get released. Okay, so they're ensuring that that's been taken care of, because it was their responsibility to get that release recorded, and we'll just go forward with our party. Prepare the title commitment outlining their findings and identify any clouds or encumbrances that need to be cleared. Clouds and encumbrances would be mortgages, HOA, taxes, liens, judgments, anything like that. Okay. Disclosing exceptions to the insurance policy. The exceptions are things that we can't insure over. Because these are out of our control. Easements, we can't do that. The utilities have a right to run easements. Let's just say your water pipe breaks down and the meters inside your yard, they have the right to go through to the meter and dig up the ground, break up the sidewalk and fix that pipe. There's nothing you can do about it because they have to provide the facilities to you of water and electric and sewer. So they have the right to go do that. We can't insure over that because they're out of our control. Right of ways, well agreements, those are gonna be an acceptance. Those are things that we can't do. CCNRs. CCNR is an acceptance because we can't change the CCR. If the homeowners association has come in there with the CCNRs, which stands for covenants, conditions, and restrictions, the homeowners association, they've had these certain requirements on there. We can't insure over those because those are in place by those parties. Those would be exceptions. The other thing we would have, like I said, easeways, utilities, right of ways, well agreements, CCNRs. Those are the main exceptions that we can't cover over. Taxes, we can't change taxes. You're gonna pay those. We can't, we can't get rid of those. They're gonna stay on there. That's just the way it's gonna be. Disclosing exception, okay, and then issuing the final title policies. We'll get that to in a little bit. As far as the escrow officer role, it is our role to be the neutral third party, the coordinator of everything. Again, we prepare all legal documents. Our fiduciary role is to prepare settlement statements and disbursement of funds. Order homeowner association payoff, coordinate lender signing loan documents as well as the seller. We coordinate the buyer and the seller signing. And then we record the required documents, okay, which basically is going to be the warranty deed, affidavit of property value, and deed of trust. On a solar, we would have UCC termination, would be required to record that as well. If you have a loan where one spouse is going in title, the other spouse is not, there would be a disclaimer deed that we would have to sign as well and get recorded. And as far as record documents, that'd be pretty much what we would be required to record on the transaction. Next we got, what is title insurance? Title insurance, it protects the buyers and lenders from financial loss against possible issues or defects in the title of the real property. This comes back to, we always have, it goes back to the contract I was talking about the names. I'm assuming everybody knows that Arizona is a community property state. So as soon as a spouse goes and buys something, the other spouse automatically owns 50% of it. If a spouse comes into title on the property through an inheritance or prior to the marriage, the spouse has no right to interest in that property because it was done in an inheritance or it was done before prior to them being married.
So I have a question there.
Okay.
So if it's community property and let's say the home is purchased in one of the spouse's names, is the married partner automatically put on the title? No, they don't have to be on the title.
They have to sign, they'd have to do a disclaimer deed.
Right. So, okay, so they'd have to do a disclaimer deed in order not to go on the title.
Right.
So if considering it's community property, can someone put okay, so let's say everything's in the husband's name and someone comes after the wife, and she's not on the deed, they can't put a lien on that property.
No,
Okay,
because she has no interest in the property. So, and a lot of times people do that too.
Yeah.
You know, because they know the spouse has judgments or whatever, and they'll just, if one spouse can get approved by themselves, they'll do that. So that, and then they'll take care of that judgment or lien, whatever the other spouse has. And then they might come on later on afterwards and say, okay, now can you add my spouse to title, which we can do. We can accommodate that as well. We do here, again, I mean, I know this sounds kind of repetitive. I'm repeating some of the stuff here. And this is something that I received last minute, but title professional, public record, property taxes, tax records, court records, establish legal ownership of property being sold, reports and determines the cure for any title defects, accounts for the insured and the insures the entire transaction against fraud or defect, whether it is known or unknown. If the claim arises, title insurance may also cover the cost of defense against the claim. We don't normally see any claims because we're on the extra side, anything that, any type of title claim usually comes after the fact, usually 6 months, years down the road from when you actually took ownership to the property. And we're never really privy to that information if a title claim has been, actually filed against the property or not. So usually a title claim would be a forgery. It would be a spouse coming back saying, hey, I had an interest in that property. You sold it without, splitting the interest with me. It happens a lot to people when they're getting divorced. We see a lot. We see a lot, unfortunately, through divorces. And the other time we see it is through inheritances because you have children fighting over it sometimes too. Okay. So that's why on the inheritance side, we'll always require a copy of the trust if it's in a trust, or it will have to go to probate. It will have to go to probate. I've had people try to convince me, no, don't have to do it. I have this documentation. I said, well, you show me proof of personal representative documentation from the court certified in the last 60 days and I'll believe you. And they're like, well, we don't need to do that because I have this. I have no, that's what I need. That requirement will ask for certified documents from the court that you've been signed personal representative of the estate of John Doe. Without that, we're not conveying title because at that point, any sibling, any possible other heir, once we close, can come back and say, hey, I was entitled to part of that property. And that's when the title insurance kicks in. They'll call the title company and say, I need to file a title claim. I was supposed to get X amount of this dollar. This was my dad, this is my brother, this is whatever. And then it goes to a legal department and then they have to start researching everything and seeing what is what.
But if the property's in a trust, then
If the property's in a trust, it's okay because we have the trust and the trust will say who the successor trustees
right, so
are.
there's nothing anyone can do.
There's nothing anyone can do.
And do you put it in a trust at the time that you purchase it, or is that something you do after you purchase it?
Either or. Usually it depends. Usually if you're getting a loan, the lender will not let you put it on the mortgage. There are some lenders that will, but from my experience, and I've been doing this since 1995, you have to have a lot of assets before they'll let you put it in the name of the trust. And when you do put it in the name of the trust, they do it inter vivos, which basically says you're putting it in the name of the trust, but you're also signing as an individual.
Right.
Because the trust is an entity, you can't really go after a trust. You can come after me,
Right,
but you can't really go after a trust. So, and that's where, but they still make you sign as an individual, so you're still individually responsible, okay? Once you've closed escrow, we can do a deed from the two of you or from the one of you or whoever and put it into the trust. And then it's protected by the trust. Okay, if something happens, we'll go by whatever, we'll have to go by whatever the trust says,
yeah,
okay? We've had situations where people have had trusts, but they didn't put it in the trust, they're not their name, then they passed away and they didn't want to use the trust, and it's like, well. Unfortunately, that doesn't help us because it wasn't in the trust, okay? So then they would have to go back to probate again, and that's where a trust will come in. A will come in and make it a lot easier and simpler when you go to the courts to try to be assigned as personal representative. These will be to your benefit to have those documentations to help expedite that process. Let's see what else we got here.
You can't say in the trust all homes.
Huh?
You can't say in the trust all homes that I own.
You can't,
They have to be identified,
the trustees have to be in.
but,
The
if you own
properties.
multiple properties, can you say all properties or if that doesn't?
They can be all properties.
no, what she's saying is, can it just say all properties, or does it have to list out the individual properties and the addresses or whatever?
Inside of the trust.
In the trust, it doesn't matter. We're gonna put the trustees on the actual deed. Yeah, okay, so then. In the problem you're gonna have is if you put it all properties in the trust. What if you,
All what property?
all what properties?
Yeah. So then you really do need to list.
To
them.
specify, yeah.
You need to
Yeah.
specify.
Addresses and parcel numbers.
Specify, and then the language would then state all properties within, listed within.
Yeah,
Right.
yeah, and I would list the parcel numbers,
Yeah.
not just the address,
Yeah.
because we as a title insurer, and I don't know if a lot of people don't know this. But as a title insurer, we don't care about the address. All we care is about the legal description. We don't care about the parcel number. I mean, we care about the parcel number, but the legal description will never change. The city can come in and change the address, the city can incorporate with another city. You know, so what we care about is the legal description, because that's what's actually filed with the county, you know? So when you take a parcel and you split it, you create a new legal description. And, you know, and that's what we, and that they'll, at that time, they'll split the parcel number. Let's just say it was 215-15301. They'll make it one of those parcels A, and then they'll make one of those parcels B. And they decide to split one of those again, then they'll make those two parcels C, D, and they'll go on, however, that original parcel, I mean, kind of split, okay? So we normally, you know, because we have lenders call us, well, you need to verify the address, the appraiser's saying this, the appraiser's saying that, I'm like, you know, what do you want on there? Because I really don't care, 'cause I'm not insuring the address, I'm insuring the legal description.
Right.
The Ron
Okay.
insurance, yeah. Okay, any other questions, anybody? No, okay. The next page. Title policy. There's an owner's policy and a lender's policy. The owner's policy protects the buyer and their heirs for as long as they own the property. In Arizona, the seller pays a fee, okay? That's customary. The seller pays the owner's policy and the buyer pays the lender's policy, okay? One little caveat about title insurance, which most people don't know, is title insurance is the only insurance in the world you pay premium one time and you're insured. Okay, it's not like auto insurance, life insurance, any other insurance. You don't pay monthly, you don't pay annually, you pay one time and you're covered. Okay. Be sure to educate the buyer if they want to change the vesting to a new entity to request an additional insured endorsement at the time of recording the new deed. If we go from, and what this is referring to is if you decide to take the property and you want to change it and you want to put it into your trust, usually if you put it in trust, into your trust, it's not an issue because you're still listed as the trustee of the property. Okay, so I'm Arthur C. DeVaca. I'm conveying to my trust. I'm a trustee, Arthur C. DeVaca, and Mickey C. DeVaca, trustee of the C. DeVaca Living Trust, whatever. They're going to be okay because I'm still ownership. A lot of times they do that same thing when you want to switch it, put it into an LLC, as long as there's only one person who's the sole proprietor of the LLC and the same person who was previously on title, that's not a problem. If you want to change it, then you contact the title insurance company, let them know what you're trying to do, and then we can normally do an endorsement to insure over that and transfer over the new ownership, okay, what you're doing. A lender's policy protects only the lender's financial interest in their real property, and Arizona buyer pays for this fee. The lender always wants to be in first position. The only person they want above them is going to be taxes. Okay, it's going to be taxes and then the lender insurance. And it goes down and steps down. They always say they want to be in first position because they want to be the very first one. Then second, third, and fourth, they don't care. They want to have the first position, so nobody above them can foreclose and take the property out from underneath them with the loan they provided on it. Basically, what they're doing there. Next we got title examination, research, the commitment. Excuse me. Back in the day, our old timers used to call it a preliminary title report, because at that time we were told that we're not committing to anything. So we can't call it a title commitment because we're not committing to anything. We're just doing a title report. This is the preliminary title report, what we're finding on record. Nowadays, they just call it a title commitment. I guess that has gone away. So trying to say we're committed to anything. Review the chain of title and current owner. Again, we discussed that, and we'll also verify it through county assessor, the last recorded deed. Again, any outstanding trust judgment, other liens against property vested owners, IRS liens. IRS liens can be fun sometimes. And I say that in a tongue-in-cheek way because they can be real pain. Some people don't want to disclose information. Some people want to deny them. Some people want to, don't do it. But we have an IRS lien. Guess what? We're not going to play with Big Brother. We're going to make sure that we get the payoff information from the IRS, not from them, but from the IRS, showing what they need to pay. And then we get them on occasion. We get them on occasion on more often on refinances than on purchases. Okay, but on occasion we'll get them on a purchase. The seller has some back taxes he has to pay, and you have to make it good, and that's what it is.
And that's property taxes.
Personal property taxes.
Yeah.
Not property taxes, personal taxes.
Oh, it can be personal taxes as well.
For the IRS. Yeah. Because they'll file a lien, and that shows up on record. And And for us, that's pretty easy because usually it has the buyer's name, I mean, the seller's name and the seller's address on it. We can know, hey, yep, this is the address of the seller. This is pretty much our guy. So we'll inform and let them know. Again, we'll let them know that we're showing up, you know,
Yeah. What about buyers, if buyers owe back taxes?
buyers can have judgments, they can have liens, they can owe taxes. And they will not require them to pay them. And the way that happens is because they would rather that party have an asset that they can require payment from,
Okay.
okay? So they'll let you buy the house,
Mhm.
and then when you go to refi, you gotta pay them out. You go to sell, you gotta pay them out. They
So
have,
you can buy it, the problem comes when you go to sell.
when you go to
Or
sell,
refund.
Okay.
or refinance,
Okay,
yeah, because it's
wow.
gonna be insured when you refinance, because the lender's gonna be insured. And for us to insure it, we need to make sure that that judgment, because what happens is you have a payoff here, you have a tax here, you have another judgment here. We pay off this lien when we close. We don't address these two. When the new loan goes on, it now become in third position. They want to be in the first position because we didn't satisfy these two. And then the lender can come after saying, hey, you know, that's the whole title insurance. So
Do you ever have any problems? Are there ever any issues when it comes to child support? Let's say if you have a seller and they owe back child support, what
it
happens?
happens all the time.
Really?
Same thing as a lien, same thing as a tax lien. We have to call CPS or DPS or Access or whoever it is. And
But
we
they
have-
can still buy. But, correct, they can
If
still
they're,
buy,
if they can still buy,
but
It just.
again,
but
if
when they
they're
go to
making
sell,
money,
when they
then-
go to sell, they have to pay that off. They have to satisfy that.
okay,
That,
let me complicate that.
Okay.
Let's say they owe child support, they buy, but then they roll it into a trust.
it doesn't matter. That doesn't matter. When they go to sell it, when we do the title search, we're gonna show that we're gonna show that they owed it as John Doe.
Right,
Even though John Doe put it in the John Doe trust, John Doe still owned it. That lien automatically attached that property as soon as John Doe took ownership.
okay, and it'll stay attached even within the trust.
Mhm.
So if they sold it back out of.
If
the
they
trust,
sold
They'd
it,
still have to pay.
they try to refund, it, you have to
Okay.
pay. Yeah, because it's a public record now. It's attached to that property.
Okay, that makes
Yeah,
sense.
and see, and here's what people don't understand. I have a lien for whatever it is. I owe somebody, right? Well, me and you make a gentleman's handshake, we make a handshake, you give me 50 grand, I give you my deed of my property. You go to refinance, you get a loan out, and they're gonna say, hey. There's a lien on here from Art. That's why you get title insurance,
Yeah, yeah,
Yeah.
because if not, it's now you're responsible, even though it's my lien, that was my lien.
but I have.
But you have to pay it because it becomes attached to that property. And that's another important thing of title insurance that people don't realize. That
Yeah.
once they, you know, because a lot of people say, oh, well, I had a title search done 2 years ago, you know, it's clean, you know, just, we'll cut out the agent, you know, we'll cut out title insurance, you know, because an agent, you're talking, you know, 3%, you know, 6%, and title fee is gonna be $1,000, you know, $1,500, you know, I mean, we can just avoid that with a handshake and we'll do the deed, you know, and
Yeah,
people have done that, and it comes back to bite them. That's important to title insurance for that reason right there. Okay, yeah, that you're insured, that you have clean title with it, okay, nothing's attached to it. All taxes are current, everything, because everything, if there's back taxes, you're responsible for them.
So if there's a FISBO and they have someone off the street that purchases, can they go to title to, okay, so they can bypass an agent and go straight to title.
I do FISBOs all the time, you know, yeah. But FISBOs, we do FISBOs all the time, we do industrial stuff all the time, you know, just more or less like a FISBO, but they do it more often, so they're familiar with the process. You know, and the contracts and that kind of stuff, you know, on a FISBO. Okay. Let's see, for easements, restrictions, access surveys and other matters. Non-insurables exceptions, again, items that run with the land, like again, the easements, the right of way, the wells, CCNR, those go with the land. There's nothing we can do with them. They've already been put on the tax land, and there's nothing we can do to remove them and insure them over them. We can't be sure that the utility company's not gonna come and dig up your ground when your sewer backs up, or
Yeah.
your cable gets knocked up, or your power line gets knocked up, you know, they have the right to come do that, you know, because they can't. I don't wanna say by law, but they can't leave you without utilities.
Correct.
Yeah, okay. After the title search, have completed a commitment for title insurance is generated and sent to PTA escrow officer for review, roadmap of the escrow for the escrow officer. Okay. At that point, once we get that, we'll send out to all, we'll send out, once we get the title report, we will send it out to the agents and their clients, informing them of what the title report reads, and if any action is required by them. Okay? Most times by the buyer, there's no action required. Unless there's a solar, they'll be required to reach out to the solar company to get the transfer started. Other than that, as far as the buyer, there's usually nothing requirement. It's just information to let them know what's on title. Policy comparison. This is a form here regarding homeowner standard policy. I don't know if you guys can see that though. I can't. I can't. No. We have a form though of that shows the difference in the policy between a standard owners, standard lenders, and then extended owners and extended lenders. I would always go with an extended because it covers you for everything. When it comes to dollars on title insurance, I would never scrimp on money because like I said, it's a policy you pay one time, you never pay it again. So you might as well get the extended so you're covered from all possible easements, any kind of items that might come up on title,
You
you're
said the
protected.
buyer pays that or
The seller pays the
seller?
owner's title policy.
Okay,
And they do that as a show of good faith. The seller shows it as good faith that, hey, I'm the legal owner. I'm conveying title to you and it's gonna be clear and
well,
clean.
isn't it typically, I mean, it's only like $1,500 or something, isn't it?
It depends on, it's based on the sales price, basically.
It depends on what.
Based on the sales price.
Okay.
The owner's policy is based on the sales price and the lender's policy is based on the loan amount, okay?
Is there a percentage that it's based on?
No, we don't do it by percentage. They don't, I'm not sure exactly how they calculate it. I didn't bring the document, the form with me on it, but it averages out to probably about 1% between all the closing costs up to the sale price. Okay, but yeah, that's the reason we get title insurance. And like I said, I've been doing this a long time and I was broke at one time, and you know, when you're broke, you want to get the least expensive thing, but I would say as far as title insurance go, I would spend the money because you're only gonna pay it one time and you're gonna be covered forever. Okay, as long as you want it. So it's worth the money to me to get it, you know.
I've never even thought you could not get it. I thought it was something that you have to do.
Well, it'd be paying cash.
Oh, if you're paying cash, you wouldn't get it?
You don't have to, but
Oh, okay.
lender always gonna require it. And the buyer usually is gonna require it too. Okay. If you have an agent that is telling a buyer that he doesn't need it,
Well, but I thought if there's a cash buyer, the only policy that you guys set up is the owner's policy, not the lender's policy.
the owner's policy, and which the seller would end up paying for.
So there is no when you're cash, you're not purchasing the lender's policy.
Right,
So there
but
isn't-
still, the owner's policy,
That's the seller, yeah.
they would still want that even with cash. you
Yes.
know. I mean, does anyone ever not want it?
No.
So,
Um,
because if you can afford to pay that cash, you know,
Right.
Yeah, but there's also, well, but it's the seller paying it, not buyer.
right,
It's the seller, not
yeah,
buyer.
well,
But isn't, you said there's there's like a extra insurance,
Yeah, it's called extended coverage.
right?
Extended coverage on there, they have homeowners extended coverage, which is I use First American, so it's the Eagle policy, it's their top line owner policy. And then you have an extended lender's policy, which covers everything as well. Okay. Also, so you know, when we do a combo, which we call a combo, which is between the owner's policy and the lender's policy, we're issuing both of those on the same transaction. We give a discounted amount to the lender's policy. The lender's policy would be like $2,800 with simultaneous. We call it simultaneous if we're doing two policies together. We normally, it'll be almost probably 60% of what the standard extended on lender's policy would be.
so you get,
You can save some money on that as well.
40%.
Okay,
So, and Rock Title gives, what is it that you give a discount on?
we give a 50% listing discount, which we give a 50%, 50% discount on the escrow fee to the buyer and the seller if the seller puts in the private mark on the MLS that the seller wishes to work with Art at Rock Title, the buyer and seller will receive a 50% discount. Yeah.
What if they don't put that, but they still use you?
then you don't get it.
Then you get great service. Either way, you get great service.
Yeah, but
it-
you don't get the discount?
No, it has to be in the MLS.
Has to
You
be
have
in
to
the MLS.
forward your MLS Plano to
Oh,
them.
that's interesting.
Because
Okay.
they have to show it, because it's recorded. So title companies record their fees, so they can't play around with their fees. All title companies record their fees.
Mhm.
And so they have a listing of what their fees are, and one of those is kind of an advertising discount
Right.
for it being advertised. So they have to have in their records for. If
So
they're
any title
audited,
company that you use, if they're going to give a discount, it has to be in the MLS?
no,
No, okay,
but it has to be on their recorded sheets.
right. That's just your little,
That's what people-
Yeah.
Can't say they gave a discount, you put it in your pocket, didn't do it.
Right.
That's how.
Yeah.
No, but it's also, so all title companies have an investor rate, right?
Mhm.
But they don't have a rate saying, yeah, if somebody uses me, this is the discounted rate. They have an advertising rate that if it's advertised, they're giving this discount. Does that make sense?
Yeah,
Yeah.
except that any title company can give you that discount. They don't have to put it in the MLS. They can still give you that discount.
But it would have to be their recorded stated discounts.
Okay,
So
We have to file fees with the
file their
state banking
discounts.
department.
okay.
So if they're gonna give everybody that discount, then it's not a discount. Those are their fees,
Right,
right? So they're giving a discount based on the advertising
of us and them.
of it in the MLS.
because you then have to turn around and record that you're giving that discount?
Yes.
Okay,
Yes, and there are a couple other companies that do something similar, but again, it has to be noted.
Okay. Now, next, we're gonna go, we're almost out of time, huh? I'm already gone over and I'm,
Yep.
it's 11 o'clock. Okay. I'm gonna go real, short and sweet here. We've already talked about the policies and everything. The final step is what we do is once we've got the signings, we'll prepare the documents, get them back to the lender. The lender will review them to make sure they have everything they need. In that package, we'll also record documents from the seller, so the lender has proof that the seller is conveying title, what they're getting back, that there's no other money that the seller is giving into the buyer. And then once the lender approves everything, they'll send us their funds. They'll give us authorization to release and record. Once we receive their funds and we have everybody's funds, the buyer's funds, we have all the money and our balances, our files balance is zero. We will go ahead and record the documents. Once recording is confirmed, we'll inform all the parties that recording is firmed. At that point, the ownership has gone to the new buyer. At that point, the keys can be released to the new buyer.
once it records.
Once it records, okay? Once it records, we go through our file, we balance everything out, we make sure all our people are being paid, and then we'll disperse all the funds. And then we'll send out final documents to all parties. We normally send out 2 final settlement statements to both parties. That way they have one for their personal records, they have one for their tax guy when they go to do the taxes. We don't know what they can write off on the taxes, it can't be. So I'll provide the parties 2 copies of the final settlement statement. I'll provide the seller 2 copies of the 1099, so they can take that, because our policy is basically, we're always gonna send out a 1099. I just got a guy yesterday email me, he closed on a deal. He's like, dude, why do you send me a 1099? I'm not subject to 1099. I said, it's our policy to send it out to you, because we're not tax authorities, we're not tax professionals. So when you go to your tax now, you have this form, in case your tax guy says, hey, I need this form, you're not saying, where's our number, what title company was that, you know, and then, I mean, it happens, we've
Yeah.
had it this last tax season, it happens every tax season. So I do it just because to help them out, and they help me out because I don't have to deal with it later. They're gonna have the documentation. They take it to the tax guy. The tax guy says, you're not subject to 1099, don't worry about it, or you got a 1099 form. Here's a 1099 form.
And
Okay.
just great tip for you as agents, in January and February, reach out to all your clients and send them last year's copy of the settlement statement, because they will have lost it by the time they get to tax season. And it's a great touch point for you to reach back out and say, really enjoyed working with you last year. Here's just a reminder, here's a copy of your settlement statement. You can pull that from your Realty One file. It is scanned in by the admin here. But please be very careful. Your checks are also scanned in and your settlement statement. It's all one package. So if you go in there to grab it because you didn't get a copy yourself, make sure you just print out the 1, 2, or 3 pages of the closing statement to forward to your clients, because that's all you want to forward. You don't really want to forward your checks. Tends to,
Okay,
Change that.
and in closing, that is what we do. And kind of in a small nutshell, but I mean, I'm sure there's some things that I didn't disclose to you. I tried to disclose to you the most important things, the most common things that we run into, and try to help expedite the transaction by the information that we need sooner than later if possible regarding mainly the solar and the party's information. On that note, does anybody have any questions? I guess that's a no.
anybody
think-
online?
And yeah, there's still 5 people online. Yeah. Thank you. Alicia,
And Mike's are-
Jennifer. Jody.
Anybody online want to jump on mic and ask any questions?
Nope. All right. Well, I thank you all for your time. And I hope I was able to educate you or enlighten you on some other things that we do on the escrow side and the title side. And like always, feel free, if you have any questions, give me a call. If you have any questions on some title issues, just want to have a conversation about something, feel free to give me a call and reach out, okay? So on that note, you guys have a great rest of your Tuesday and have a wonderful rest of your week, okay? Thank you very much.
Hit stop share. And then down at the bottom, hit end. No, end. And in meeting.